Good afternoon and welcome. I'm Brian McCann. I'm here with Chris Cavalli, and we are partners at Callagy Law and also certified matrimonial law attorneys. And we're going to be discussing with you today the evolution of legal custody and what that means in terms of the relationship between you and your children. And there's no better place to start than understanding the definitions of legal custody and how those apply. Chris?
Thanks, Brian. There are two types of legal custody arrangements. The first is sole legal custody, and the second is joint legal custody. Sole legal custody is an arrangement where one parent has the right to make all major decisions regarding a child's health, education, and welfare, and does not need the other parent's consent to make such decisions, and may not even be required to consult with the other parent before making such decision. The other type of custody arrangement is joint legal custody, and that is an arrangement whereby both parents will make major decisions regarding a child's health, education, and welfare, and the presumption is that both parents will act and make decisions which are in the child's best interest. The parents will have equal decision-making authority, and this type of arrangement requires communication and cooperation between the parents on an ongoing basis. Brian, tell me a little bit more about joint legal custody, which certainly seems to be the norm nowadays.
Sure, thanks, Chris. To better understand where we are, it's always helpful to understand where we were. Pre-1981, and you'll understand why I say pre-1981 in a minute, our courts were largely granting sole legal custody to one parent with parenting time to the other parent. That was the predominant legal custody decision pre-1981. And a lot of the times, not surprisingly, that legal custody was granted to the mother because it was presumed at that time that the mother was more involved, especially with children of tender years. It was called the tender years doctrine. But that evolved in 1998, specifically in 1981, with the Supreme Court's decision of Beck versus Beck, which formally recognized joint legal custody as an alternative to the sole legal custody arrangement. And really what happened in that case is our Supreme Court recognized that sole custody determinations were becoming a problem because one parent was feeling as though they won in a litigation and the other parent was feeling as if they lost. And those sentiments would carry over into the post-judgment phase of cases where there was a lot of disputes and a lot of arguments and a lot of fights, and would eventually end back into court. And so that type of feeling towards sole custody gave birth to this joint legal custody in Beck versus Beck, where they wanted to recognize both parents' right to be involved in decision making. There was a lot of psychological input in that, and it became the public policy of our state that a child's best interests are generally fostered when both parents are involved with the rights and responsibilities of child rearing. As a result, joint legal custody really became the presumed result of a custody litigation. Now, there is no presumption in our law of joint legal custody, although, as Chris and I will tell you, and as Chris just said, it is the trend. It is the default legal arrangement, absent some other showing of why it shouldn't be. So our courts really, or our legal community really pushes joint legal custody as the favored result in all of these cases. And I will give you some examples which you may find contrary to reasonable belief that a joint legal custody wouldn't be involved, where you have this arrangement where you have to have both parents making equal decisions. Take, for example, where parents live in separate states, where you have a parent in New Jersey and a parent that lives in California. That will still have a joint legal custody arrangement absent any other circumstances. And you may think, how is that possible where you have this great distance between two parents and they have to have equal decision making? There are cases, that have been involved in that situation where that says modern technology is now at a state where you can actually have that arrangement through email or text messages or FaceTimes or video conferencing, where that great geographical limitation will not impose any burden on the joint legal custody arrangement. So that's a perfect example of our courts trying to find ways to make the joint legal custody arrangement work. We've also had situations, I've had cases and Chris have had cases where one parent suffers from a mental health disorder, a bipolar disorder or some other mental health disorder that may in fact at times either in the past or in the future affect their judgment. But even in those situations, a joint legal custody arrangement is still a favored arrangement, allowing that parent to have equal involvement in the child rearing responsibilities, all on the basis and foundation that that involvement is in the child's best interest.
Clearly, it seems that absent some real big reason for one parent not to have joint legal custody is overwhelmingly the norm in the agreements and even courts' decisions. Certainly, if one parent totally abandoned the family and it can't be found, that would be a ground. Or if one parent has a severe problem, is a criminal or a lifelong drug addict that has no chance of rehabilitation or is in jail, those extreme situations would certainly lend itself to a sole custody arrangement. But I've also found that it can really come down to like an ego issue or a control issue. Even in cases where one parent was never involved in any of the decision-making regarding the child and may have been an uninvolved parent, for lack of a better term, that parent, when it comes to a divorce, all of a sudden says, I want to be involved in the decision-making going forward. Whether that sentiment is genuine or not genuine, the courts are usually going to favor a joint legal custody arrangement. And again, sometimes it's as small of a thing or as big of a thing as someone's ego saying, I'm not going to let you make all the decisions regarding our child, regardless of whether you made them in the past or not. And similarly, a control issue. I want to have a say going forward with major decisions regarding our children, regardless of the fact of whether or not I used to be involved in these decisions when we were married. Go ahead, Brad.
So that's absolutely what the Beck versus Beck court was concerned with, having that kind of ego be involved in creating disputes down the road. So that gave birth to the joint legal custody that we have. And as Chris was defining sole legal custody and joint legal custody, it gets broken down into the decision-making ability of the parents. And that decision-making ability gets broken down into two categories of minor and major decisions. And Chris is going to talk to us a little about what that means.
Right. When we talk about legal custody, whether that's sole legal custody or joint legal custody, that refers to major decisions for the children. So whether or not it's one parent's authority to make those decisions or both parents' joint authority to make those decisions, those would be major decisions. And major decisions would be defined as decisions which impact a child's health, education, and welfare. Examples would be choice of the child's school, the children's religious upbringing, healthcare choices, which doctors to go to, which procedures may or may not be necessary for the child, travel outside of the state, and sometimes even selection of the children's activities and sports and extracurricular activities. Minor decisions are made by the parent who is caring for that child on a day-to-day basis. So regardless of sole or joint custody, if a child is in one person's care for the week or the weekend, that parent would be able to make the minor decisions. And the minor decisions are your normal day-to-day decisions or routine decisions regarding a child. Those would include what the child's going to eat that day, when the child is going to bathe, and maybe even how often the child bathes over a weekend or something like that, what clothes the child's going to wear, scheduling of maybe minor activities, taking the children to the park or letting them go on play dates, maybe some smaller discipline issues. Again, discipline can be defined as a major or a minor decision making, I guess, depending on the severity and the length of the discipline. As an example, if one parent decides to take a child's cell phone away for an hour because they said something wrong, I would define that as being minor. But if either or both parents decide to take the child's cell phone away for a month, or they're grounded for a month, that might be a major decision. And if it is a joint legal custody relationship, the parents have to discuss, communicate, and cooperate on that type of issue.
And so, if anyone's out there that is going through this right now or contemplating this right now, a great tip would be to make sure in any agreement that you eventually enter into that you define what you consider to be a major decision and a minor decision. And it may seem simple enough. Chris just gave us a definition of what those things are, but there are some cases in our state that have been very vague on that and have come down on what you and I may think is a major decision and considered it minor decision. I'll give you a perfect example of a case that happened in New Jersey where the mother, the parent of primary residence, took their child to a doctor after a fall, and that doctor recommended surgery. The father, who was the non-custodial parent, then took the child to specialists in New Jersey who said that they didn't think the child needed surgery. That resulted in a bunch of litigation over whether this child needed surgery, and ultimately the court decided that the mother, as the primary residential parent, had the right to make that decision. And we'll talk about what that means later on. But the way that the court got around that is that they found that that surgery was a minor decision that happened during her parenting time, her time with the child. And I think we all could agree that a surgery is not a minor decision, but it found a way to defer to the non-custodial, to the custodial parent, to qualify it as a minor decision that the custodial parent was able to make absent the consent of the custodial parent. So the tip would be to make sure you define what you consider to be a major decision in your agreement.
So in that case, Brian, even though we always say that major decisions are decisions regarding, health, welfare of the children, that's health and that's welfare, yet the court deferred to the custodial parent and labeled that a more minor of a decision?
It was a minor surgery. It wasn't a major surgery. It was a minor surgery to correct a small nose issue as a result of a fall. But they considered the custodial parent's right to make that decision over the objection of the non-custodial parent. They found a way around it.
Right. Certainly, you can see the other side in that argument.
Absolutely.
So, as we know, right, that the joint legal custody is the overwhelming norm, and it is by agreement or by court order, the law of most of the cases. So, Brian, tell me what you have found are some difficulties with implementing joint legal custody.
Absolutely. First, even in 1981 with the case Beck versus Beck, the Supreme Court recognized that joint legal custody was only appropriate in a very limited amount of cases because the arrangement creates instability for children. It causes loyalty conflicts. It makes maintaining parental authority difficult, which is one of the issues that Chris was just describing regarding discipline. And it aggravates an already stressful divorce situation by requiring these parents to be in constant contact and constantly communicate with each other regarding decisions for their children. So the rise in joint legal custody arrangements has also given rise to disputes. So implementing that joint legal custody arrangement is difficult. It's difficult, and that difficulty was expected because you can't have parents that are engaging in this hostile divorce environment then have to then remove themselves from that immediately and start compromising and communicating and respecting each other and trusting each other to make these decisions and separate out that hostility. Now, our courts have impressed upon the legal community not to measure the parents' ability to cooperate based upon their their attitudes and their behavior in the divorce process, but rather based upon their ability to cooperate prior to the separation and prior to the hostility of the divorce. The idea being that once the divorce is final, any anger and animosity will subside and the parents will return to the prior level of cooperation and civility. That certainly isn't always the case, especially in high conflict divorce cases. That tends to carry over. There's lingering animosity, and there's an inability to make decisions regarding joint decisions regarding the health, education, and welfare of their children. And that presents a real problem for the court system and for the legal community and for the parents, and more importantly for the children, who ultimately become victims of their parents' inability to agree on these decisions. So it causes a lot of increased distress and emotional and financial distress on the entire family. So we get into this situation where joint legal custody is a favored outcome, but causes the rise in these disputes. And so when we have the disputes, Chris, what happens when the parents can't agree?
Well, unfortunately, a lot of times when parents can't agree, they have to resort to going back to court. Either parent will file a motion, usually which is then met with a cross motion with the opposing point of view, and each party will put forth their position on the certain decision that they can agree upon regarding the child. Now, the court can certainly just make a decision on that one issue and be done with it. And if the issues are very crystallized and the facts are pretty straightforward, and one party says it should be this way and the other party says it should be that way, the judge can just easily make, enter an order and say, I agree with either parent. More than often, the judge is going to find a way to either not make that decision, but put the parties into a position or a process where they can better make that decision themselves with the help of experts, or the judge may actually send them to mediation to make that. But the judge is going to not only want to make a decision on that one issue before the court, but the courts are going to want to put the parents in a position where they can have a process whereby future decisions, just like the one before the court, are made without coming back to court. Because clearly, a family part judge doesn't want to have a motion a month by every parent after their divorce on issues regarding the children. So it is very common that the court will appoint experts to help parents make these decisions. One of the most common appointments is the appointment of a parent coordinator. A parent coordinator is normally either an attorney or a mental health professional who is charged with the duty to make recommendations on parent and minor parenting time issues that arise between parents. That parent coordinator will usually speak with or meet with each parent individually, sometimes jointly, but usually individually, and can also reach out to other people that'll help them make their recommendation. And normally, the parent coordinator will make a recommendation only, and that recommendation will either be followed by the parties, or if the parties can't agree on the recommendation of the parent coordinator, one of the parties will go to court to enforce that recommendation. In some circumstances, and I just had a case like this where there's high conflict parenting issues, the parties will agree on certain issues that the parent coordinator's recommendation is binding unless the other party goes to court to challenge that recommendation and has it overturned. In cases where parents can't agree that the sky is blue or it's raining or it's sunny out, it's not a bad idea to do that, especially if you define exactly what issues the parent coordinator can make a recommendation which will be binding on. Those are normally not huge decisions, and they're not parenting time decisions or change of custody or change of actual parenting schedules. The court can also appoint educational experts, which will help the parents decide which school the child may go to, and will do an evaluation of the child and the child's whatever reports the child has, and look into the schools and make that recommendation. The court, if there's a relocation issue, if one party wants to move out of state with the child, the court can appoint an expert on that issue to make a recommendation. The courts also commonly appoint mental health professionals for the parents and the children. Some parents need counseling and how to co-parent. Some children need therapy. Sometimes there's a situation where a parent doesn't not have a good relationship with the child, and the court can appoint a reunification therapist. Lastly, the court sometimes, in maybe a little bit more extreme cases where the disputes are bigger, will appoint a guardian ad litem, and that guardian ad litem is normally an attorney who looks at it from the child's point of view and evaluates the situation, meets sometimes with the child, almost all the time with the child, and the parents and all other collateral sources, and makes a recommendation on a number of issues that what is in the child's best interest, and recommends that the court follow a certain plan, which could even be appointing a parent coordinator and mental health professionals going forward.
So what Chris just went through should kind of give all of us a little bit of a pause here, because we have a court system and a legal community that says joint legal custody is the favored outcome now. And we've had a rise in disputes because of the joint legal custody being the favored outcome. And when there is a dispute, we now are back into the court system where we are going to have the appointment of any number of other professionals to get involved to help parents make these decisions that they can't make on their own. And the financial cost becomes enormous, and the emotional cost becomes enormous. And there are long-term disadvantages of the children that have to go through this, most importantly. So, I mean, I've had cases, and I know Chris have had cases that have gone on for years just on these issues of where a child is going to go to school, what kind of dental work does a child need, what kind of medical work does a child need, should a child travel outside of the United States on vacation. I've had cases that have gone on for years and years and years at the cost of tens to hundreds of thousands of dollars over the life of a child because the parents cannot make these decisions. So it goes back to the Beck versus Beck case, 1981, that's saying that this joint legal custody arrangement is really for a limited number of cases where the parents can actually work within that kind of arrangement. So there are certainly a lot of considerations that need to go into this, and there are trends in our court in decisions that have resulted because of the joint legal custody arrangement. And Chris, can you kind of help us explain some of that?
Sure. I guess the rhetorical question is, and I'm not going to put you on the spot to answer it, but I guess I just pose it, is if giving everyone joint legal custody leads to so many disputes, why is it the norm?
Well, again, because it's the public policy
Right.
of our state that both parents being involved in the decision-making and the child rearing of their children is to the benefit of the child.
Well, thanks
for
for
the child's best interest.
Thanks for answering the question, even though you didn't have to. So we found that there is some trends in court decisions and even agreements. It makes sense if sometimes either the court orders or the parents would agree to give deference to one of the parents for a certain issue, especially giving deference to the primary residential parent. Under the thinking that that person, the primary residential parent, is around the child more, knows the child's tendencies, knows the child's needs. So if it's a close call, that a lot of times, I guess even going back to the example Brian made before with that minor surgery, the court may defer to the custodial parent's decision-making if it's a close call and the parents can't come to an agreement on it. Certainly, the court or the court can order, or the parties can agree that there's an obligation for both parents to communicate and cooperate, but maybe that the residential parent has the final say on a certain issue, which doesn't bring us to the next topic, which Brian and I really think is the way things should be going and are going to a certain extent, and that is with respect to hybrid arrangements. Can you tell us more about that?
Sure, absolutely. But before we get there, I want to just give everyone a quick example of what Chris was just talking about, of a case that was decided a number of years ago in 2005, where both of the parents exercised joint legal custody, and the father became the residential parent. Now, the father was Jewish and the mother was Catholic, but the children were raised in both faiths even after the divorce. Eventually, the mother sought to compel the father, the residential parent, to allow the oldest child to enroll in religious classes that would consume all day, every Sunday. The father objected to this, and extensive litigation ensued over this. And ultimately, the court said the father, as the primary caretaker, had the right to decide the children's religious upbringing. Now, those parents had joint legal custody, but ultimately, just as Chris was saying, the court deferred to the father as the primary caretaker to determine the children's religious upbringing. And so the tip from that as well, for anyone out there that might be going through this right now or contemplating it, is that when you enter into these agreements for legal custody, make sure in that agreement, especially if you're the non-residential, non-custodial parent, that the agreement says specifically that just because I am, the mother or the father is the non-residential parent, doesn't mean that the residential parent has a greater decision-making authority on any issue that we've defined in this agreement. Just because there is a lot of deference to the residential parent when there's a difference or dispute on conflicts with that. But as Chris was transitioning to, we were talking about what a trend is now, in a recent trend that we're noticing from a pure joint legal custody, we're moving into what's these hybrid arrangements now, where parents split decision-making responsibilities or alternate decision-making responsibilities in different domains regarding their children's life. And this is often referred to, always referred to it, as far as I've seen, as parallel parenting. And what happens is you have parents splitting up certain decision-making. You'll have mom decide where a child goes to camp, and you'll have dad decide what extracurricular activities the child is enrolled in. Those decisions are final. You'll have mom decide the religious education of the child, and dad decide where the child goes to school. Those decisions are final. So you're splitting up equally these major decisions between each parent. Rather than having each parent have to make those decisions together, you're assigning the right to make those decisions to a single parent. So,
and again, that can be, they can communicate and cooperate on that, but maybe one of them has the final say,
correct,
right?
Correct. It's not, it's a hybrid of the joint legal custody. Because of all the disputes that have been arising when joint legal custody is the favorite outcome, where both parents have an equal right to every decision, we've now evolved into this parallel parenting. And particularly in high conflict cases where the parents are continually not able to make decisions, continually going back to court, then this parallel parenting gets in place under, usually under a therapeutic and mental health professional's guidance on how to make these decisions and plan out this parallel parenting schedule. But it really is an evolution of the joint legal custody now. And it's not really, it doesn't represent equal decision making in the pure joint legal custody sense, yet it provides both parents with the right to make major decisions. So it's still keeping in line with our public policy that both parents being involved in the decision making is better for the children. It's an effort to strike a balance between protecting the children from ongoing parental conflict, yet maintaining and encouraging parents to share in their rights and responsibilities of raising their children. So we've noticed that that's a trend, these hybrid arrangements and this parallel parenting, and quite frankly, in the high conflict situations, it's a welcome trend to try and keep parents involved and de-escalate the matter.
Right, and when you think of it, it just makes sense in a lot of situations, right? Because every case is different. All the facts are different. Parents' interactions with children and what they did during the marriage and who was responsible for making what decisions is different in every case. So when you take it on a case-by-case basis, for instance, maybe dad was always involved in the children's sports and always coached their teams and was very, super involved in all of the sports that the children did, and mom was always really involved in their religious upbringing and was, the teacher at the religious school or ran the program. It would just make sense if after the divorce, in that type of situation, dad would have the final say on what sports the children are involved in and what teams they play on, and mom would make the decisions regarding the religious issues. So I think at some point you have to just practically look at it and have a common sense approach to, keep letting the parent who was always involved and really good at making certain decisions, let them have the final say in those decisions moving forward. So in conclusion, we all realize that joint legal custody is the overwhelming norm, and that there's a lot of reasons for it, and there's a lot of good things about it. And in a perfect world, parents would always communicate and cooperate with each other and always make decisions jointly based upon the children's best interests. However, we know that in reality that doesn't always happen. And we really think that the trend in those cases is, as we just finished up with, is those hybrid arrangements where we let the parents who are most suitable, the parent who is most suitable to make those final decisions, make those final decisions. And it's very important, if you're going through issues of custody in your divorce case, or even post-judgment custody issues, that when you choose a lawyer, you choose a lawyer who will listen to what you have to say and will advocate for your position, and will not just tell you what they think the law is or the norm is, but actually come up with solutions to the problems that you present. And you need to find an attorney who will approach this in a caring, urgent, and aggressive manner, and will, again, listen to all of the facts of your case, listen to what you have to say, and then come up with the appropriate settlement proposal. And if we can't settle the case, then, present your case to a court, again, in a caring, urgent, and aggressive manner.
Absolutely. So we've provided you in about 31 minutes joint legal custody in a nutshell. Obviously, every case is different. It's very fact specific, and there are a lot of ins and outs of it that we could spend an entire afternoon discussing and talking about. But hopefully, we've given you some information that you found helpful, that can put you on the right track in making decisions within your family. And if you have any other questions, feel free to contact either Chris and I. We're happy to meet with you and speak with you and provide advice. And so, again, thank you for attending, and we hope everyone has a good day.
Thank you.